All right, since we don't have a lot of people, what we thought we would do, if you have questions during this webcast, go ahead and email Don Ray, and he's going to give you his number.
Well, you've got my email on the face of the program. So just email me with a question, and I'll keep my eye on my emails, and we'll just answer your questions in real time here.
Okay. Historically, of course, the Lincoln program is no different than a number of other programs that have come down the path in the last few years, where the manufacturers basically have grabbed the gross profit margin they used to allow the dealer, squeezed it down, and then made the dealer earn it back. Turn this off. So it's not new in that respect, and this has kicked off a huge nationwide discussion, some legislation by a very few number of states relative to the disproportionate impact of incentive programs. There's also been some litigation in this area as to whether or not such programs violate discriminatory pricing. In Robinson-Patman, there was a case in California against Chrysler on such a program. That was not successful, but I think it's maybe going to come back around again. It was handled by mine in Wisconsin. But in any event, so this program gets into this larger question of incentives. And of course, what's interesting is that the manufacturer squeezed the margin and is now trying to make you earn it back. And some of you are not in a position where you're ever able to earn it back because of the nature of your market, the size of your facility, and so on. That leads to a lot of legal questions which have not largely to this point been answered. We did submit a bill to the legislature last year on behalf of ADAI, and that bill met very stiff resistance. And then, of course, the entire last half of the session, ADAI was preoccupied with trying to take care of the class action litigation, which we discussed in yesterday's doc feed. So basically, Don highlighted a couple of points here, and then we'll get into the statutes that might be of some help.
One of our alert readers provided the official notice letter from Lincoln, and it would appear that these official notices went out on or about August 12, so you might want to check the date of the love letter that you received. In essence, the program takes a big hunk of the 5.75% program margin currently available downward to 3%, effective July 1 of 20, unless you have a standalone Lincoln store meeting the Lincoln Vitrine design standard. I don't know what Lincoln Vitrine is. I don't know about Vitrine.
What is Vitrine? Yeah.
Yeah, I don't know. So you still have to earn back that 3%. Theoretically, you can do so without having a standalone, but you'll have to have a car wash, received loaner, offer pickup and delivery, and have modem activation. That gets you 1.5. And also accelerate purchases, have CPO sales and training for another 1.5. A certified dual store, in other words, a store that is not a standalone but is certified, still gets a 1% spiff until the second quarter in 2022. I've not been able to tell exactly when in the second quarter. I think that's a little vague. As noted, to qualify, if you do go the standalone route, it must be Lincoln Vitrine compliant, and that is referenced at the last page of the exhibit, which is captioned Lincoln Vitrine facility process.
Okay, in terms of some things that might be helpful if anyone or a group of you choose to take any action, which we'll discuss a little bit later what the procedure is and so on, under Indiana statutes. Now, I'm not going to take these in the order that they are presented. I'm going to take it kind of in what I view at least is the longest and strongest. And for that, go down in the middle of the page to where we're citing IC 932-13-23 and down to A2. All of you that are currently dualed received Ford and Lincoln approval to dual. Now, these are separate franchises, but they are basically the same manufacturer. So the legal position would be that you have a dual facility representing essentially two franchisors in your facility. So with that, of course, A2 comes into play, coerce or attempt to coerce a dealer to divest ownership of another line, make the dealer's established require written approval of the manufacturer. So by virtue of the predatory or abusive pricing that comes in with regard to the incentive, that acts in our judgment potentially. Obviously, this has never been litigated before. There are some states now that are considering that, and we'll talk about one in a minute. But that has a coercive effect on the dealer so as to force the dealer essentially to divest the Lincoln into a separate type of facility. A4 comes into play a little bit, requiring a dealer as a condition of continuing a franchise to construct the dealership, modify or change the location of the existing dealership. Now, it's not a condition of continuing the Lincoln franchise. However, the net effect, going back to employment law, the net effect of the action is to be coercive and require that modification or change of location, constructing a new dealership. I don't know that. I think in some instances there, I believe joint service facilities can be allowed. That's always a potential possibility. And there is another prohibition in that statutory section that deals with prohibiting a dealer from representing more than one make of vehicle from the same facility if reasonable facilities exist for combined operation. Dealer meets reasonable capitalization requirements and prohibition is not justified by reasonable business considerations of the manufacturer. Now, where this comes into play with the dual facility and most of the smaller markets certainly is that it's economically unfeasible for you to have to build a separate location with all the cost incurred in that to sell 5 and 15 units perhaps a month. There's just no way that you can make that work without setting yourself up for substantial losses.
Now, the loophole that the manufacturer tries to invoke in a situation like this is that this section, and all of what Ron just talked about is contained in a section. This section does not prohibit the enforcement of a voluntary agreement between the manufacturer and the franchisee where separate and valuable consideration has been offered and accepted.
Now, that's not going to apply unless there's money involved, like the General Motors EBE program or its successors, or the Nissan program that was around for a few years. So that is a separate and distinct, and that's why the statute essentially says separate and valuable consideration. So the mere fact that you still continue with your Lincoln franchise, I think, is going to take that argument away from the manufacturers. Now, there's also another statutory section that comes in, and I have this now in 2 or 3 cases. One happens to be a Subaru, where the dealer was certified as being facility compliant 3 or 4 years ago now. And then in about 2 months, the manufacturer changed its units in operation measurement to go from 5 to 7 years, I think it was, which popped the units in operation up. And of course, he was a recipient of a letter from the manufacturer that said, guess what? your facility is no longer facility compliant, so in order to, you need to break ground right away and do this, that, and the other to your facility after a couple $1 million had spent to make it facility compliant. We wrote back to Subaru and said, cited this section and said, we'll see you in 2023. And they in fact restored the 2% that they took away from him. So this could be available to some of you if you were certified as facility compliant within the last 7 years. In my judgment, this is an absolute bar to any action to coerce you to build a separate facility if you've been certified facility compliant in the last 7 years. Now, in that case, they came back and said, well, your term agreement is up in 2019, so we'll talk with you there. Then we did get a letter this summer. We sent back and said, no dice, we're going to talk to you in 2023. So in any event, that is a helpful section. Now that in terms of, there are 2 exceptions to that statute, neither of which are probably applicable. One is technical changes occasioned by technology, which typically thus far has been charging stations, or something that's mandated by law relative to handicap, equal access type things. So those are sections of the statute that principally come into play. And again, they're not direct, but they are essentially tangential to this reduction that they're proposing in the margin, that essentially has this negative or coercive effect on the dealers to do this kind of work. And then we go up to the first bullet point in Roman S2, unfair practice of coercion by the manufacturer to coerce the dealer. There are other coercive statutes that come into play in the general franchise statute. For those of you that haven't heard us talk before about franchise statute, Indiana has a dual track franchise statute that affects statutes, plural, that affect dealerships. One is the general franchise statute, which has been on the books forever, not been improved much of anything, that originally set out to take care of McDonald's and Arby's and places like that, but by specific amendment was engrafted onto the dealer rights statutes, which appear in 932.13. So we can make some use of both of those statutes, and there are some provisions in the general franchise statute which appear on 3. There's one thing we left out of that. The general franchise statute prohibits prejudicial acts. And of course, we also have our usual argument about prohibits discriminating among fair franchisees or failing to refuse to comply with the term of the franchise.
One of our audience members has emailed asking whether there's too much precedent set to be able to put together a credible offense to reverse this. And our response is, we do not think so. There's really not precedent going one way or the other in Indiana. So we're free to make these arguments. We think these arguments do have a sound legal basis. And, you know, it's like the old Ed McMahon letter, you could already be a winner.
Now, let me make a point here. This is not dissimilar to the Genesis issue that a couple of years ago, correct, Joel?
Yeah, I was going to say, a lot of this does kind of harken back to some of the Genesis issues and material changes in your foundational franchise agreement, which you can take them to task for. There's some elements in this matter as well.
And what happened in the Genesis situation, and the Indiana dealers that took Genesis to task on this got a lot of credit initially, because there were a couple of other states and a couple of other, let's see, Florida, Louisiana, Texas, Indiana, not the state, but the dealers that took that program on. And it backed that into a corner, and Genesis relented and said, okay, you can have the Genesis franchise in your existing dealership, dual it for as long as you have that particular dealership. And then there were some negotiated changes with regard to how it operated operationally. So that did not go all the way to a hearing in Indiana. It was settled out, but some of the same principles apply in this Lincoln case.
Yeah, and that is one of the reasons why there isn't a lot of precedent, is because we usually, it seems like historically, have settled it either mediation or before the actual administrative action is concluded.
And of course, it was settled in these other states that on the Genesis thing also.
Another question has come in. In addition to the facility issues, Lincoln will not allow us to sell black label vehicles, and they have also been limiting our allocation of product over the last few years. Are these also coercive behaviors?
Yeah, absolutely. And this goes back years, and Ford put another, I can't remember the model of the vehicle out, and they were denying that to dealers. And the several state associations, including us, went to bat, and they decided they weren't going to pick that fight. I forget what the vehicle was. This has probably been about 20 years ago.
Was it Aurora?
No, Aurora was Oldsmobile.
Because there was a similar issue back in the day with Aurora, and I know that we did some work for some Olds dealers arguing that if you're an Olds dealer, you get to sell every brand of Olds, and that includes Aurora.
Right.
So cutting you out of black label, which is just another model, is not right. Incidentally, one of our alert watchers notes that vitrine rhymes with latrine.
Yeah.
That could be it.
They better watch out. Remember the error that Chevrolet made, and what was the
Nova.
the
Nova.
Nova, which in Spanish means junk.
Nova means doesn't go.
But anyway, so okay, what's the process if anybody chooses to move forward? Obviously, nobody can predict success, and success has to be measured in increments, I suppose. But procedurally, in the state of Indiana, if one or more would decide to file a protest, the protest is filed with the Secretary of State. Contemporaneously with that filing of the protest, or as a condition precedent, which in our means before, you can demand mediation as a precursor to filing a protest. Most of the time you file the protest and you have the mediation. The parties select a mediator, and then you sit down and try to see what can be worked out relative to the statute. Now here, you get some pushback because the manufacturers are going to say, well, only 3 or 4 states, or only dealers in 3 or 4 states are protesting this, so you guys are really oddballs for doing this. Or they will say, no, this is an incentive. We're not taking away your franchise, but of course that doesn't recognize the coercive effect on your operations. If the mediation fails, and sometimes that goes on for a period of time, going back and forth, then the Secretary of State makes a determination as to whether or not they think that the statute has been violated, and they will perhaps order a hearing, perhaps enter an order, as they did in the General Motors case a year or so ago, on the reimbursement for warranty and parts. There's some other things that kind of come into play if this moves forward. There are hiring of experts that would be necessary, and particularly if it goes to a hearing. You may want to have some preliminary economic expert take a look at it to talk about the reasonability. And a couple of these guys are pretty well primed. There are 2 firms in the United States that do this work: Anderson Economics of East Lansing, Michigan, and Fontana Group from Tucson, Arizona. Now, I've worked with both over the years, been on with both, and they're both good, solid firms. Both of them have the ability to project cost, lost profits, things of that nature as a result of the imposition of management or the lack of taking away incentive programs. In this kind of a situation, again, one of the buzzwords is the functional availability of the program to the dealer. And the manufacturers always argue every dealer's got the right to participate in this program. And that's always their comeback argument. And the response to that is that because of the market conditions, because the most that you can be expected to sell is a few units a month, that means that program is functionally unavailable to you. Because to take advantage of it, yeah, you could build it, but you'd go broke. Obviously, the manufacturer reaps some profits because it's cutting margin to the dealers. For anybody that can't qualify with this program, Ford presumably is getting an extra 2% on all of their.
Well, in fact, one of the folks listening in on this call observed to me that he believes that this really doesn't have anything to do with dueling at all, that it's a pure money grab. Simple, because Ford knows that most folks are not going to be able to have economic justification for a standalone Lincoln. So this is really just a cynical ploy to give you guys a haircut.
Well, and I somewhat disagree with that. I think that's a side product of it. I think all of these manufacturers over the years get caught up in these new programs, and if somebody does something and it looks like it's going to work, whether it works or not, then everybody follows suit. Of course, one of the first ones that started this was the Cadillac program, and we see how well that worked out for Cadillac. So these things, and of course, right now we're seeing how well some of these subscription programs are working for manufacturers. They're absolute economic disasters. They could have been predicted, but they won't listen to anybody. And so once they get on some kind of a kick, then everybody tries to follow suit. So I think it may be a combination of those, but I tend to think that the economic thing is they thought up this to be like other luxuries, and then the light went on and said, hey, we can save a couple of points here. The damnable fact is simply that this used to be the gross profit margin that the dealer had to try to make a living off of, and they've squeezed that and now made people try to earn it back. So in any event, where do you go from here? I think you need to determine, we have 20 dealers, Lincoln dealers in the state of Indiana. California, oddly enough, I think only had about 38 in that letter that we got from the California Association. They pushed back. We wrote a letter, I think, for somebody, a couple letters last year. And of course, that resulted in a 6-month delay in the implementation of this program. Now, it doesn't look like they've changed anything too much. But and I think California is going to try to do something. We will take a quick review with some people in other states to see if there's any perhaps concerted activity going on in other states. That would not have any bearing on what we do in Indiana. And again, Indiana was the only state that challenged General Motors 20-some years ago when they disbanded local marketing groups, other than the Chicago organization. But Indiana collected $26 million from General Motors, $18 million cash on the hood, and $8 million in advertising. But so that doesn't necessarily mean what you're going to do here.
On the contacts with other states, as you know, we're members of the National Association of Dealer Council, and to the extent people are fighting the same fight, we all share arguments and approaches and information gleaned. Did speak a couple days ago to NADA about this, and they are working on this quietly with their industry relations group. NADA does not get into legal issues that are state specific. They strictly stick with national issues, but in this particular situation, as in others, their industry relations group, which is not really a legal group, but rather kind of a collegial reach out to the other side, let's talk this over function, is working on it. And basically the message that they're giving to Ford is, come on guys, this is just stupid. You really shouldn't do it. It's causing a lot of consternation. There is the observation that, and NADA is always sensitive to this, that because they represent all dealers, there are inevitably interest groups involved, and Lincoln dealers that are already dualed probably kind of like this.
Standalone.
I'm sorry, the Lincoln dealers that are already standalone kind of like this. The folks who are dualed are the ones with a problem, and they probably divide into roughly two groups. One which feels the necessity to do something about it, and the other which feels that the Lincoln operation is small enough that the economic impact isn't worth sweating. So I think those are probably the three worlds into which Lincoln dealers fall. And whether you all want to put together a group of aggrieved dual dealers to try to pursue this in the manner we've described here is up to you. And we're certainly happy to host discussions to put a group of that nature together.
Yeah. Now, as far as timing is concerned, I think I remember in here that the first requirement was effective, I think, in October. So I think a good, if something is going to be filed with the Secretary of State and the mediation demand kicked off, then it should be done by the 1st of October. And I actually probably prefer to do that around September 20th. That involved filing a protest, which is a formal legal document with the Secretary of State demanding mediation. Then it sits with the Secretary of State until the parties meet and see if anything can be mediated out. There's all kinds of things that can happen in mediation, further delays in implementation of a program or some kind of a carve out or something of that sort. The trick in settling these things in mediation is to make them part of a settlement agreement and not changes in the franchise agreement or changes in the program. Because if you say, well, as we want you to change the franchise agreement, of course they go ballistic and say we can't do that because we'd have to change everybody in the country, and some people are not protesting this. So there's ways to work around all of that stuff. And we may or may not be successful down the line. If the mediation doesn't work, you go to the Secretary of State. They will order a hearing on it and enter an order on it, and it can go through the court system after that. So I think it might be worthwhile, based on our experience with Genesis, to file the protest and see what can be mediated out. There's no saying if the mediation doesn't work that you can't throw in the towel at that particular point. There's certainly plenty of argument to support this. We have a question: if we're on term agreements, does pursuing this ensure our demise or renewal on our term agreement? No, because it is an unfair practice for the manufacturer not to renew an agreement for BS reasons. So if they were to say, okay, we're not, I mean, that's just blatant retaliation. The answer to that is a flat no. term agreements, there's going to be some interesting, I'm not going to get into that now, there's going to be some interesting law based upon a potential North Dakota Equipment Dealer Association case that we had a small part in. But in any event, the answer to that should be no.
So if anyone has any more questions, get to sending me the email now. We'll wait a couple minutes to see if any more questions come in. And I think that in terms of communicating with us, you know where to reach us, and we can put together an email group to discuss future options and the approach to this.
And expense sharing and whatnot, and whether we want, I probably would suggest that we visit with one of the firms at this point, and then probably the one that I know that's doing some looking at this is the Tucson, Arizona group, Fontana. I probably would call them and just shake the tree to see what they want to do. If you are interested in moving forward and perhaps participating, obviously there's no commitment even when we get down to allocating what we're going to do. I would suggest that you go ahead and email Don. I'm going to be traveling a little bit, and then we can try to see where we are after the holiday, schedule something for those people that are interested in moving forward, see where we go.
I'm going to be going to Auburn on Friday, so I'm out too. So,
well, but you've got you can contact me. I mean, I'm going to be working. Hell, I work all the time, 7 days a week. Just going to be out of pocket this afternoon, and I'll be working all weekend. So you can get a
yeah, we'll be around. You all know us. So let's see. Well, I don't see any new things coming in over the wire, so I
okay.
guess we're done.
Thanks,
Thanks, everybody.
thanks, folks, and we'll touch base later then.